All rise. Oyez, oyez, oyez. All those having business before this honorable court draw near and they shall be heard. The Honorable Judges Brenner, Johnson, Sullivan, with Chief Justice Basanta presiding. God save the United States and this honorable court.
So we had to get set up. Well, the case before us today is the State of Franklin Department of Social and Health Services petitioners versus Sarah Kilborn, respondents, and the United States of America intervening respondent. Are the petitioners ready?
Yes, Your Honor.
Respondents?
Yes, Your Honor. May it please the court. Petitioner respectfully requests to reserve 2 minutes for rebuttal.
2 minutes.
Yes, Your Honor. My name is Allie Morrison, and along with my co-counsel, Braden Oglesby, we represent the State of Franklin Department of Social and Health Services, petitioners here and defendants in the trial court. Allowing those who may never be institutionalized to bring a claim would impermissibly open this court's doors. There are 2 issues on appeal. In my time before the court, I will show why the Court of Appeals erred by impermissibly expanding the text of Title II to include those who are not currently institutionalized or segregated and allowing them to bring a claim under Title II of the ADA. In Mr. Oglesby's time before the court, he will show why the Court of Appeals also erred by allowing the United States to intervene when it lacks the authority to do so under Title II of the ADA. As to the first reason, that those who are not currently institutionalized or segregated cannot bring a claim for discrimination under Title II of the ADA, there are 2 main reasons in support. First, allowing those who are merely at risk of institutionalization is barred by the plain language of the integration mandate. And second, the Department of Justice's interpretation of the integration mandate is not entitled to deference under Auer versus Robbins. This issue is reviewed de novo, as pointed out in United States versus Mississippi. The state of Franklin is geographically large, but sparsely populated, as shown on page 15 of the record. In 2011, after the federal government cut the state of Franklin's budget by a jarring 20%, the state was forced to close 2 of its community mental health care facilities. Respondents are Franklin residents who have all been hospitalized in the past. However, as shown on the record on page 1, none of the respondents are currently institutionalized. Their claim is prospective, that without additional community mental health care facilities, they may, at some unknown point in the future, be institutionalized again. And it's under this risk that they've brought their claim. Beginning with my—
Let me ask you something though. Would you agree that each of the respondents during their prime, they've all been institutionalized before, and the state did not provide appropriate treatment for them, facilities for them. So they've all been subject to a violation of the ADA. They just didn't sue back then.
Yes, Your Honor. All the respondents have previously been institutionalized and had doctors who recommended community-based healthcare. However, the respondents are not suing based on this past harm that they've endured. They're suing on the basis that they may, at some unknown point in the future, suffer this harm if they're not allowed to bring this claim.
So they have to just wait, go through the they have to have the need for the treatment again and undergo I would say, inappropriate institutionalization before they can make any claim. They have
Yes,
to
sir.
suffer real harm before they can.
Yes, Your
Even though
Honor.
before you did violate the statute, the state did.
Yes, Your Honor. And while that result may be unfortunate, it is what the text of the integration mandate and the statute demands, that the respondents and the plaintiffs must be actually institutionalized in order to bring this claim. The integration mandate, which is found in Title 28 of the Code of Federal Regulations, Section 35.130, subsection D, states that entities are required to administer services, programs, and activities in the most integrated setting as to the needs of the qualified individual with disabilities. Entities like the state of Franklin cannot administer services or programs to individuals who are not currently institutionalized. Additionally, the plain text of Title II, which is Title 42 of Section 12132 of the Title II of the ADA, states that qualified individuals shall be denied, shall be denied services or administered programs. This shall be indicates that the legislature intended that the respondents would have to be currently institutionalized and suffer that harm, not that one day they may suffer that harm.
Haven't they been determined by their physicians, indeed, though, to be at risk future future issues?
Yes, Your Honor, their physicians have determined that. However, there's nothing to sufficiently limit of when a person is qualified as at risk versus not. So if this court were to allow individuals who are classified at risk to bring a claim, then it begs the question of where would this end? Would states like Franklin have to defend claims against individuals who have never even been institutionalized? Would they have to build community healthcare facilities on the corner where every person with a mental health disability lived? Already, just to comply with the respondents' claims, the state of Franklin would have to build and staff 3 facilities that may never even be used because there is no guarantee that these respondents will be institutionalized again.
Has the state of Franklin done anything to improve the situation since it violated the ADA previously? Has the situation gotten better?
There's nothing in the record to indicate what actions the state of Franklin has taken. However, Your Honor, the fact that one community mental health care facility does still exist in the state, as reflected in the record on pages 12 through 15, shows that the state of Franklin is still in compliance with the ADA. There's nothing in the integration mandate or the plain text of Title II that requires a mental health facility, community health care facility be within a specific distance of the respondents. So the fact that one still does exist in the state is in compliance with the ADA.
But in fact, most of your citizens are outside of a reasonable driving distance of this existing facility. Is that not correct?
Yes, Your Honor. While most of the citizens of the state, as shown on page 12 of the record, do live far distances from this facility, again, because of the nature of the state of Franklin, being a large geographic state, but sparsely populated, can also be inferred that most of the citizens would live far away from any services that would be provided regardless of the nature of the service.
Are you saying that's irrelevant that they live far away? That as long as there's one facility in the state, that takes care of it?
Yes, Your Honor.
Oh,
This court has stated in Bostock versus Clayton County that when the text of a statute gives us one answer and the extra textual considerations give us another, there is no question. Only the written word is law. So regardless of whatever noble intentions may be behind a policy argument for the respondents, the plain text of the integration mandate and Title II control. As pointed out by the 5th Circuit in United States versus Mississippi, the reasoning by the 10th Circuit in Fisher versus Oklahoma Healthcare Authority is entirely backwards. Fisher reasoned that because nothing in the plain language of the statute expressly barred the court from allowing those who are merely at risk to bring a claim, that it was permissible for the court to read in such a group. This goes directly against the canons of statutory interpretation. If something is unprovided, it's just that, unprovided. This court cannot read in what Congress expressly omitted. Allowing so would be requiring Congress to anticipate every group that it wished to exclude and explicitly exclude those groups. Such a result would be impractical and impossible. Turning to my next point, the Department of Justice's guidance document interpreting the integration mandate, stating that individuals need not be institutionalized or at risk of imminent harm of institutionalization in order to bring a claim, is not owed deference under Auer versus Robbins. Previously, under Auer versus Robbins, agencies' interpretations of their own regulations were automatically given deference so long as that interpretation was not plainly erroneous or inconsistent with the regulation. Kaiser versus Wilkie goes on to narrow the scope of Auer by requiring 5 additional elements to be met in order for an agency's interpretation to be given deference. And while failing just one of these 5 elements is enough for an agency's interpretation to not be given deference, this Department of Justice guidance document most notably fails 2. First, that it's not the agency's official or authoritative position. And second, the regulation is not genuinely ambiguous. As to the first reason, that is not the agency's official or authoritative position. The very document itself includes a disclaimer that 1, it's not intended as final agency action, and 2, it has no legally binding effect. As to the second reason, that it's not genuinely ambiguous, Kaiser explains that to be genuinely ambiguous, ambiguity must be treated as a last resort, after all other tools of statutory interpretation have been exhausted. As previously mentioned, nothing in the plain text of the integration mandate includes individuals who are at risk of institutionalization.
So it's not, it's a plain meaning, is what you're saying, that the statute is clear. How do you reconcile, you've got one circuit court that agrees with you, right? The Fifth Circuit.
Yes, Your
Do
Honor.
any circuits disagree with your position?
Yes, Your Honor. There,
Most of the circuits, don't they? So
Yes.
tell me about that. Explain that, or they're just all wrong. They just don't understand.
no, Your Honor, but 5 of the 6 circuit cases shown on the record on page 12 were handed down before the Kaiser versus Wilkie decision. So all of these circuit court cases were automatically given the Department of Justice's interpretation deference under the lower Auer standard. When Kaiser versus Wilkie came out, it added the 5 heightened standards. None of these circuit court decisions established or analyzed any of those heightened requirements. There are 2 circuit court cases that came after Kaiser. One being the United States versus Mississippi case, which establishes that individuals who are at risk cannot bring a claim. And 2, the Washtenaw versus Washington Community Mental Health Care Facility. And this case stated that it did not need to determine whether or not the regulation was genuinely ambiguous in order to give the interpretation deference, which blatantly disregards the Kaiser factor that the regulation must be genuinely ambiguous in order to be given deference. So while the majority of circuits may have held that individuals who are at risk can bring a claim, all of these circuit courts, besides Fisher versus Oklahoma Healthcare Authority, heavily relied on the Department of Justice's guidance document before the heightened requirements were required under Kaiser versus Wilkie.
Is there a standing issue here that we should?
Yes, in part, Your Honor. Because these respondents are not currently institutionalized, they do not have the standing necessary that is required under Title II of the ADA in order to bring this claim before the court. In order to bring the claim, they would have to be actually institutionalized as the plaintiffs were in Olmstead versus L.C. Zimmerman. Because as the Fifth Circuit points out in United States versus Mississippi, the ADA defines discrimination in terms of actual risk, not hypothetical administration of programs. And as Chief Judge Hoffman pointed out on page 35 of the record, any other reading of the integration mandate would be requiring states to be prepared to administer services.
So why should we follow the United States versus Mississippi?
Yes, Your Honor, because the United States versus Mississippi should be followed mainly because the facts are so analogous to the plaintiffs here. In that case, the U.S. brought a suit alleging a systematic violation of Mississippi's statewide community mental health care infrastructure. Likewise here, the plaintiffs are alleging that the state of Franklin has not complied with the ADA and does not offer sufficient statewide mental health care facilities. There, the Fifth Circuit held that the United States had failed to prove an actionable discrimination claim because there was no plaintiff who was currently institutionalized, which is precisely the facts that are here. Additionally, the circuit court cases that held that individuals who are at risk can bring a claim can be distinguished from this case because all of the plaintiffs in those cases were currently and actively receiving care or the administration of programs or services, such as in Fisher versus Oklahoma Healthcare Authority from the 10th Circuit. Those plaintiffs were receiving prescriptions and they were having the prescriptions cut back. So while all of those plaintiffs were currently receiving care or services, the respondents here are not currently institutionalized. They are not receiving any services or any care as of this moment.
Does the record say that they're not under the care of receiving prescription?
No, Your Honor, it does not say that. However, it does show on page 1 of the record that none of the respondents are currently institutionalized. In conclusion, Your Honors, petitioners have shown here that the Court of Appeals erred by allowing those who are not currently institutionalized or segregated to bring a claim for discrimination under Title II of the ADA for 2 reasons. 1, because it's barred by the plain text of the integration mandate, and 2, because the Department of Justice guidance document should not be given deference under Kaiser versus Whitby. For these reasons, petitioner respectfully requests, I see that I'm not.
You can finish your sentence.
For these reasons, petitioners respectfully request this court reverse and remand. Thank you.
May it please the court. My name is Braden Oglesby, and I also represent the petitioner, the State of Franklin Department of Health and Social Services. I'm addressing the second issue on appeal, that the 12th Circuit erred in holding that the United States has the authority to sue under Title II of the ADA and allowing them to intervene in this case. The decision below should be reversed for 3 reasons. First, Title II's text provides remedies, procedures, and rights only to any person alleging discrimination, and DOJ is not a person. Second, even if the United States can sue, DOJ did not pursue voluntary compliance first. Third, and finally, absent a clear statement from Congress, courts should not expand federal enforcement against the states. This issue should be reviewed de novo because it involves purely a question of statutory interpretation, which is whether the United States has the ability to file a lawsuit through Title II's plain text. This court in Pierce v. Underwood said that statutory interpretation questions are always reviewed de novo. Therefore, this court need not give any deference to the lower court's rulings whatsoever and gets a fresh look at this case. Beginning with my first point, Title 42 of the United States Code, Section 12133, provides remedies, procedures, and rights to any person alleging discrimination. Notably, nowhere in Title II's text does that say anything about the Attorney General or DOJ. Return Now Incorporated v. USPS tells us what we already know in common sense, that person does not include the sovereign. Black's Law Dictionary also confirms the ordinary meaning. A person is a human being. It does not include an agency or a collection of letters such as DOJ. Additionally,
I want to make sure I'm clear on something. So the way you read this, it's not just the Department of Justice. Government can't intervene in this case. Across the board, they can't bring an action, any form of action to enforce the ADA.
That is true, Your Honor. They do not have the statutory interest required under Title II's text to have them have the authority to being able to bring a lawsuit. Even if they did have the ability to file a lawsuit, they still could not intervene in this case because they did not pursue voluntary compliance. In United States v. Cooper Corporation, this court held that courts should not expand the term person to include the sovereign absent a clear statement. Implicitly, using section 12133 to cover the Attorney General or DOJ when it did not specifically say it is the exact opposite of a clear statement and what United States v. Cooper Corporation warns courts against doing. And specifically, Congress knew how to separate the federal government and persons when it wanted them separated, because they did so in both of the titles surrounding Title II. In Title I, which is codified in statute at Title 42 of the United States Code, section 12117, Congress used the exact same remedies, procedures, and rights language, but also specifically included the Attorney General. On the other side of that coin is Title III in section 12188B, where Congress specifically says the Attorney General may also bring suit for injunctive relief. Title II's text mentions nothing about the Attorney General like Titles I and III do. This would also go against the anti-surplusage canon of statutory construction. And in this court, in Russell of the United States, said that when Congress includes certain language in one section of the statute, but omits it in another, that is presumed to be intentional. And the express.
Don't we have to, plain meaning is one rule, right? It doesn't trump everything. And one of the things we have to do is read the whole statute. And we have to give meaning to every word in the statute. And what are your thoughts about that? Your plain meaning approach is just too simple. There are other words in this statute, short statute, but other words, cross references to other statutes. Do you want us to ignore those, or should we trace out where those cross references take us?
Your Honor's inclination is correct. It is not that simple because we do have to look at the cross references, but the cross references provide us with that same answer. Title II cross references to Section 505 of the Rehabilitation Act, which cross references to Title VI of the Civil Rights Act. But Title VI and the United States v. Florida answered this question by treating the remedies, procedures, and rights as if it silently expanded who may sue, when it already incorporated rights that exist, which DOJ litigation has always been included in Title VI in Adams v. Richardson and Cannon v. University of Chicago. But the plain text, while it is not the only thing to look at, it is the first step in this court's analysis. And by not specifically naming the Attorney General in Titles I and III, their express references to the Attorney General there would be completely useless if Title II implicitly covers person to include Attorney General. And Title VI's cross-reference, which is those remedies, procedures, and rights, does not leave the Attorney General without the authority to enforce the regulations that Congress promulgated them with in Section 12134. This is because Section 602 of the Civil Rights Act provides that the Attorney General may effect compliance through the termination of federal funds or by any other means authorized by law. The termination of federal funds is where the Attorney General may enforce these regulations. They can still investigate. They can negotiate with the state of Franklin in their letter of findings. They can have a hearing. They can have funding consequences. They just cannot file a lawsuit in district court because Congress did not clearly grant them the authority to do so.
So this is all super interesting, and we can quibble about this, but I guess I want to get down to the real question, which is, if the United States is barred from representation, how does this affect your case? Why does it?
The United States cannot be in this lawsuit because Congress did not allow them the authority to do so. But as for this case specifically, respondents have filed their lawsuit and they are the proper vehicle for adjudicating the rights of themselves and for the individuals in Franklin. They have a lawsuit. They requested an injunction on page 16 of the record, and the United States requested that same injunction on page 24 of the record. Additionally, the record shows on page 28 that settlement may be frugal now that the United States is involved, and pointed out by Chief Judge Hoffman in his dissent. So that is how it affects this case here. And Florida treated those remedies as if it moves who can sue, which is in contradiction to this court's admonition in Alexander v. Sandoval not to imply causes of action that Congress did not clearly grant, and that they should not be based on purpose alone. In conclusion to this point, the text controls. Congress knew how to speak when it did so in Titles I and III, but it just chose not to in Title II because it never wanted them there in the first place. To my second point, even if the United States can sue, DOJ did not pursue voluntary compliance first. Long before Title II was enacted, The Attorney General established procedures through the Rehabilitation Act and Title VI that included an administrative complaint process before filing a lawsuit. And this is in Title 28 of the Code of Federal Regulations, Section 41.5. It is after an investigation reveals a violation that is attempted to be resolved through informal means first, and that is in Section 80.7D. It is only then the Attorney General may effect compliance through the termination of federal funds or by any other means authorized by law. Here, there was none of that. The state of Franklin and the United States never had a chance to negotiate because the United States never attempted it. There was no notice, there was no hearing, there were no funding consequences. It was just referral to DOJ so they could file a lawsuit in federal court. The record shows on page 3 that respondents filed their complaint in February of 2022. They completed their investigation in early May of 2022. It was just a few short weeks later that they intervened in this case, which can be distinguished from the United States v. Florida case, which respondent is sure to cite to. There, DOJ sued Florida, alleging that its Medicaid policies forced children with complex medical needs into nursing facilities rather than the community-based care that their doctors recommended. But there, DOJ spent 10 months negotiating with Florida in their letter of findings to.
Isn't that up to the Department of Justice? I mean, are we supposed to supervise? You want us to supervise it, right? And say, oh, you moved too quickly here. Even though this litigation is going on and it might affect the Department of Justice, you can't proceed yet. We'll tell you when you can.
Not necessarily, Your Honor. This court shouldn't be supervising DOJ, but it does need to hold it as a prerequisite to filing suit, just like the court in Florida did when they held that determining that voluntary compliance was not forthcoming was a prerequisite to filing suit in the first place. There, it was 10 months that it took.
But it's the patients that filed the suit, right? It was already underway.
Yeah.
So the Department of Justice is just trying to, that train has left, that there's a suit underway. They just want to get in and not have DOJ's position prejudiced in the litigation by intervening. That's the point of intervention, isn't it? Or part of the point of intervention?
It is a point of the intervention, and it would go to the first factor of timeliness. But as for the ability to file a lawsuit in the first place and to intervene, the United States must first attempt to negotiate through informal means to present them with their letter of findings and give the state of Franklin an opportunity to restructure their facilities. And here they give them no such opportunity. And it's not just the United States v. Florida case which says this, it's the district court case, the United States v. City and County of Denver, as well, as shown at page 27 of the record, when they cite to the statement determining that voluntary compliance is not forthcoming. Secondly, we can look at the official legislative history of the ADA, which was passed in 1990, when both the House report and Senate report explain that it's only after administrative mechanisms fail. They use that exact language, only after determining that voluntary compliance is not forthcoming. Therefore, even if the petitioner and even if Title II's text provides the remedies, procedures, and rights wholesale incorporating Title VI, if they overcome the steep hurdle of rereading Title II's text to include what it did not say, their lack of administrative mechanisms and remedies ends the inquiry altogether.
Is there anything else in the legislative history that is instructive here?
Yes, Your Honor. The House report and the Senate report both explain, which respondent cites in their brief, that they intended the Attorney General to file a lawsuit in district court, but that history never made it onto Title's text. Even if it did, their lack of administrative mechanisms would end the inquiry because they determined that as a prerequisite to being able to file that lawsuit. To my final point, when federal law reshapes the federal-state balance, this court in Gregory v. Ashcroft requires courts to speak clearly. And that is why Titles 1, 2, and 3 are actually different in the way they name the Attorney General. Title 1 covers employment, which is private. Title 3 covers private accommodations, but Title 2 covers public entities. And that is why the Attorney General was named in Titles 1 and 3, but not in 2, because they didn't want federalism concerns of the federal government encroaching on state lines in a public entity lawsuit. Gregory v. Ashcroft requires courts to speak clearly on this issue. And by not naming the Attorney General in Title 2, they did not speak clearly. Permitting DOJ anyway here adds a second sovereign to a state versus citizen dispute, which is precisely the type of federal expansion that Gregory instructs courts to avoid absent a clear statement. And in any event, respondents have already requested the same injunction as the United States, and their case is a proper vehicle for adjudicating their rights. In conclusion, Your Honors, The text controls, and the United States did not attempt voluntary compliance first. For these reasons, petitioner respectfully requests this court reverse and remand on both issues. Thank you.
Good afternoon, Your Honors. Chief Justice, Associate Justices, may it please the court, my name is Kavita Rai, counsel for respondents, Ms. Kilborn, Ms. Teresi, and Mr. Williamson. I will be addressing the first issue regarding why individuals at risk of institutionalization can maintain a Title II claim under the Americans with Disabilities Act. My co-counsel, Salim Lee, will be addressing the second issue regarding the Department of Justice's motion to intervene. Protection must be proactive. This court should affirm the lower court ruling for the following two reasons. First, Title II does extend to individuals at risk of institutionalization. Second, the DOJ's interpretation of its integration mandate is entitled to our deference. Regarding my first point as to why Title II extends to individuals at risk of institutionalization. Petitioner emphasizes on the plain text, yet undermines the purpose of the ADA and the overall statutory canon to look at the statutory scheme, and that the ADA was intended to be administered in a proactive manner before placing potential individuals in places of discrimination, such as institutionalization. However, when even looking at the plain language of Title II, language such as excluded, denied, and subjected is ambiguous on its face, as it does not indicate as to whether prior institutionalization, despite individuals in this case not being institutionalized, should be considered given the nuanced nature of mental health conditions.
How can there be standing if these patients are only at risk of future institutionalization? How can they have standing?
Your Honor, while standing is not a certified question in this case, as seen on the record on page 39, these individuals can bring a right to claim based off of their at-risk status. And that is what this court is here to determine today.
Could you repeat that for?
Yes, Your Honor. Respondents are able to. This court is here today to determine whether respondents have a right to care. And it is the respondent's argument that these individuals, based off of their at-risk status, do have a claim under Title II based off of the ambiguous nature of the regulation and based off of this court's previous understanding of unjustified segregation in Olmstead. Turning back to the plain text, Congress does not have to create a statute in order for it to be valid. Congress does not have to create a statute in its complete form in order for it to be valid. Congress empowers agencies like the DOJ to fill in the gaps of statutes by promulgating regulations that further reinforce the overall intention of the ADA. The DOJ did this through the integration mandate, which states that services, benefits, and activities must be administered in the most integrated setting appropriate. Nothing within the plain text of the integration mandate suggests that at-risk individuals are restricted from receiving integration mandate protections. Further, in this court's ruling in Olmstead, unjustified segregation hinges on three factors: whether medically appropriate care was denied, the consent of the plaintiffs to receiving community-based care, and the state's ability to provide such care based off of their resources.
But has anybody been denied care here? I mean, I know it happened before, but it's not happening now, is it?
Your Honor, while the three respondents are not currently institutionalized, their previous medical history of prior institutionalization and being in and out of state Franklin hospitals while being denied the physician recommended care of community-based care puts them at substantial risk, which deems them to face the same consequences of a deprivation of social life and community life that was outlined in Olmstead as discrimination under Title II. Further,
It just seems to me, I'm sorry, but it just seems to me, I'm not even sure that we have a case or controversy here. I mean, an actual current case. This is like a hypothetical. Sometime in the future, your clients may need care, and it might be that at the time, whenever it is, that the state of Franklin doesn't have appropriate care for it. But that's just speculation. It's not a current case, and we don't have jurisdiction if there's no case or controversy.
Your Honor, the respondents in this case do not face speculative harm. And further, the state remedying respondents' claims will not be an overnight fix. Once these individuals face discrimination through institutionalization, under Olmstead, they are already deemed to have Title II protections because of their institutionalized status. And while this is
Any person who has been admitted to a mental health facility a couple of times, they are at risk of readmission in the future?
Your Honor, prior institutionalization is a relevant factor when determining at-risk status and the potential of being institutionalized. Returning back to Chief Justice Basanta's point regarding whether these respondents at hand have a speculative claim or have actual standing. I'd like to direct the court's attention to one of the respondents in this case who has faced prior institutionalization and has been in and out of Franklin State Hospital facilities. Sarah Kilborn has a long history of severe bipolar disorder, requiring repeated institutionalization. Despite her best efforts to manage her condition without community-based health care, Kilborn was faced with institutionalization in 2011 for 2 years, then readmitted in 2018 for another 2 years. Each time, her physicians recommended community-based care that this state denied her, as seen on the record on page 13. The decision in Olmstead does not hinge on institutionalization status, but rather the consequences that result because of institutionalization. And while these individuals may not be institutionalized right now, they face the same consequences of a deprivation of community life and the ability to see their family, their friends, and potentially seek employment. Petitioner errs in solely relying on the Fifth Circuit Court case, which is not analogous to the case at hand. In United States versus Mississippi, the court did not have a plaintiff. Rather, the DOJ was alleging statewide discrimination against Mississippi. Here, the respondents' claims are not hypothetical. They have all faced prior discrimination, as Chief Justice Basanta has pointed out, and given the nuanced nature of their medical conditions, are likely to face substantial risk of institutionalization. The Federal Circuit Court cases, 6 out of 7 of those cases, have all extended protections to individuals at risk of institutionalization. Petitioner also errs in stating that these cases are erroneous solely because Kaiser versus Wilkie standard is not applied. As a first matter, petitioner erred in arguing that Kaiser versus Wilkie is an elements-based test when it is a factor-based test. And our deference, solely based off of ambiguity, is still a substantial and relevant factor in determining whether the DOJ's guidance document should be entitled deference. Beyond the deference point, these 6 out of 7 Federal Circuit Court cases relate to the case at hand. For instance, in Fisher versus Oklahoma Healthcare, a 10th Circuit Court case that ruled that individuals were at substantial risk due to their denial of medication. Similarly, these individuals in this case cannot receive care because they were denied their physician recommended care in the first place. The physician recommended care to seek care within their community integrated. As Chief Justice Basanta questioned, respondents have to suffer inappropriate care. That is what they are at risk of. Nothing has gotten better since the state's initial discrimination while they were still institutionalized. And while Franklin has underwent budgetary constraints to close 2 community mental health facilities, it is still within their realm, given a 5% budget increase, to ensure that individuals, and not just these respondents, but the 70% of Franklin residents that currently cannot access community-based healthcare have access to it. Turning to my second point regarding why the DOJ's guidance document is entitled to our deference. Our deference under Our versus Robbins is established when an agency's interpretation is established when a regulation is ambiguous on its face. Based off of the plain language of the integration mandate and petitioner's point and reliance on the sole present tense verb administer, this does not further indicate as to when Title II protections through the integration mandate should be enforced. Further, the integration mandate's language that states a qualified individual with a disability does not expressly restrict individuals at risk of institutionalization. Therefore, the regulation is considered ambiguous. Even under the heightened requirements under Kaiser versus Wilkie, the DOJ's interpretation is still a fair and considered one. Fair and considered judgment is often contested when there is surprise. However, the state of Franklin knew of this problem given the 70% of Franklin residents who cannot currently access care if they wanted to, because it is 2 hours, at least 2 hours away from where they are located, as seen on the record on page 15.
Let me just ask you, because I thought I heard the petitioner say that's irrelevant. If there's one facility in the state, it doesn't matter. There's no violation. If they have to go hours and hours to get to you. Now, I might have misheard, but do you have a response to that?
Yes, Your Honor. It is insufficient to only have one community mental health facility located in a sparsely populated state like Franklin, where 70% of its residents cannot access that facility if it needed to. One facility is insufficient and is not considered a reasonable. And under the fundamental alteration test, which does provide states a defense in that states do not have to remedy respondents' claims if it would lead to a fundamental alteration of its programs. This is not the case at hand here. Mere budgetary constraints, as outlined in Olmstead, is insufficient to create a fundamental alteration. A fundamental alteration must truly dismantle a state's mental health program rather than merely stretch its resources. The respondents at hand did not have a choice in not receiving community-based healthcare. This was an illusion of choice. Each of the respondents were 3 to 4 hours away from their physician-recommended care, which required being integrated in their community. So petitioners' argument that one community mental health facility is sufficient for the entire state of Franklin is erroneous. Briefly turning back to my last point regarding Kaiser versus Wilkie, expert-based judgment was utilized. The DOJ is the original author and enforcer of this regulation. It is within their authority, as granted by Congress, to ensure that the ADA is administered in a proactive manner. For these reasons, Your Honor, because the plain text of not only Title II, but the integration mandate are ambiguous on its face, and this court has held in Olmstead unjustified segregation does not hinge on institutionalization, but rather the consequences that these respondents face right now, and that Kaiser versus Wilkie established that our deference is established for the DOJ's guidance document. This court should affirm the lower court ruling and hold that individuals like these respondents can receive Title II protections under the ADA before harm continues. Thank you. Proceed. Good afternoon, Your Honors, Chief Justice, Associate Justices, may it please the court. My name is Todin Lee, counsel for respondents, Ms. Kilborn, Ms. Torrisi, and Mr. Williamson. Protecting Americans with disability is not just a legal duty, but a fundamental right that this government must uphold and enforce. Therefore, respondents respectfully request this court to affirm the decision of the lower circuit and allow DOJ's motion to intervene for 3 reasons. First, DOJ has legitimate institutional interest in this matter under Title II. Second, DOJ's sovereign interest cannot be adequately represented by the existing parties, and it will be impaired if their motion is denied. Third, DOJ timely intervened without prejudice. As a preliminary matter, petitioner erred by categorizing the standard review as de novo, as this court should review the district court's grant of intervention under abuse of discretion. This court in Cooter and Gell versus Harmar's Corporation said, when reviewing fact-bounded matters, the trial courts are uniquely suited to make those decisions, and therefore abuse of discretion is the proper standard. In this matter, majority of prongs of Rule 24A2 require entirely fact-dependent analysis. Thus, this court should review district court's grant of intervention under the abuse of discretion. Turning to my first point. Petitioner erred that DOJ does not have authority to enforce in this matter under Title II. However, Title II's language and structure explicitly confers DOJ's legitimate institutional interest. Petitioner misinterprets Title II by overfixating on Titles I and III. As Chief Justice Basanta mentioned, and as well as this court has noted in King versus Burwell, that a statute must be read as a whole, not by individual phrases. ADA is comprised of 5 different titles. While Title I and III includes self-contained enforcement clause, which does spell out DOJ's role directly, Title IV, which only allows enforcement to Federal Communication Commission, simply says the commission shall enforce this section. If Congress truly meant to limit enforcement action to private plaintiffs in Title II, then Title II would incorporate a similar structure to Title IV of the ADA. However, this is not true, as each title of the ADA includes distinct enforcement mechanism tailored to its subject. Title II instead incorporates Civil Rights Act's enforcement scheme, which authorizes Attorney General's enforcement. And as this court held in Central Bank of Denver versus First Interstate Bank of Denver, this court warned against interpreting a statute based on legislative history or congressional silence, as those cannot dictate what is at face on this matter. The language of the enforcement section in Title II states, the remedies, procedures, and rights set forth in Rehabilitation Act shall be the remedies and procedures and rights of Title II. This Rehabilitation Act in turn incorporates the enforcement scheme of Civil Rights Act, which authorizes Attorney General's compliance by any other means authorized by law. Title II of the ADA provides no further definition to what other remedies, procedures, and rights are available. Therefore, this court should look at the plain text of the Title II, what the Title II states, and see the incorporation of the Civil Rights Act's enforcement framework. And this court has set the precedent in Cannon versus United States of Chicago. In Cannon, this court dealt with the question of Sex Discrimination Act, which explicitly incorporates Civil Rights Act's enforcement scheme, just like how Title II of the ADA also incorporates Civil Rights Act's enforcement scheme as well. And this court in Cannon said, when Congress enacts a statute incorporating a provision of an earlier law, it is presumed to have acted with full knowledge of the judicial interpretation of that earlier law and have intended those interpretation to carry over to the new statute. Congress did not mistakenly take out DOJ in Title II. It is Congress knew what they were doing when they enacted Title II by incorporating the Civil Rights Act's enforcement scheme in Title II.
How do we know that Congress knew what they were doing?
Yes, Your Honor. This court in Barnes versus Gorman held that the punitive damage is not allowed under Title II because Title II's remedies, procedures, and rights are imported from the Civil Rights Act, and Civil Rights Act does not allow punitive damage. Moreover, from what this court had held in Cannon versus University of Chicago, where they held that such incorporation does include the importation of enforcement mechanism. This court's interpretation of Title II's remedies, procedures, and rights in Barnes versus Gorman further confirms that this court has interpreted Title II's the remedies, procedures, and rights to be fully imported from the Civil Rights Act. And therefore, in this matter, following the precedent that was set by this court should also interpret Title II's enforcement scheme by the Civil Rights Act and allow Attorney General's intervention in this matter. Petitioner further mistakes by overfixating on the word person in the enforcement scheme of Title II. DOJ in this matter is not intervening as a person being discriminated. Rather, DOJ is intervening as an enforcer of those person's rights, which in this matter is Ms. Kilborn, Ms. Torrisi, Mr. Williamson, and as well as entire state of Franklin. Petitioner misrelied on return mail versus USPS. Return mail deals with American Invents Act, which is a patent dispute, and its enforcement provision does not contain any notes to Attorney General. However, in this matter, Title II of the ADA is a civil rights statute, which does explicitly incorporate Attorney General's enforcement role through the chains of incorporation in the plain text of the Title II. Beyond the text of the enforcement provision, as the records, page 7 of the record notes, the general purpose provision, section 12101B3, and regulatory provision, section 12134, further shows and confirms that DOJ has authority to intervene in this matter. The general purpose provision states that federal government plays a central role in enforcing Title II standard. Further, regulatory provision states that Attorney General shall promulgate regulation. It will be self-defeating for Congress to authorize and delegate DOJ with such great central role and the regulation role, but deny those very regulation authority to this court. Petitioner erred by claiming that DOJ
did not follow through their own voluntary compliance. As petitioner mentioned, as held in 11th Circuit in United States versus Florida, and also held in DC Circuit, Adam versus Richardson, that there needs to be only a determination that voluntary compliance is not forthcoming. As cited in page 2 of the record, DOJ has investigated in this matter before intervening for almost 3 months. DOJ acted promptly, not prematurely. The 3 months itself speaks for the due diligence that the DOJ has investigated in this matter before confirming Franklin in violation and also confirming that the voluntary compliance is not forthcoming. Therefore, because DOJ has explicit authority by the Congress to intervene in this matter, and because DOJ also diligently followed through their own guideline, DOJ has legitimate institutional interest in this matter that was rightfully delegated by the Congress. Turning to my second point, DOJ has a sovereign interest that the 3 existing respondents cannot adequately represent in this matter. Rule 24A2 requires adequate representation and impairment of interest if the motion is denied. While this court has set the precedent in Trocovich versus United Mine Workers that while the burden is on the intervener to show that their interests may not be adequately represented, if their intervener's interest diverges even partially from the existing parties, then the intervention is warranted. In this matter, as page 2 of the record notes, DOJ has an enforcement mandate that goes beyond the narrower interests of the 3 respondents in this matter. While it's true that if the 3 respondents alone prevail, that the state of Franklin needs to make some changes, however, the scale and permanence of this relief or reforms are not guaranteed without the DOJ. In contrary, if the DOJ intervenes and prevails, then the state of Franklin must make the changes for the entire state of Franklin to stop the unjustified segregation. This can include statewide injunctive relief or ongoing compliance relief. And further, DOJ's interest will be impaired if their motion is denied in this matter. As discussed, Congress vested the DOJ with a central role in enforcing Title II standards, which includes DOJ's enforcement authority to bring nationwide relief to the state of Franklin. Also, the result would be devastating if the DOJ's motion is denied in this matter. It will not only impair DOJ's enforcement role, however, it will leave the further enforcement of the ADA fragmented and incomplete, as further enforcement of the ADA will depend on private plaintiffs, usually vulnerable individuals with lack of resources. As Justice Johnson mentioned, DOJ intervention in this case particularly matters. As cited in page 9 of the record, respondents are at risk of being forced into the settlement without the DOJ's intervention because they have to litigate against the state entity by themselves. DOJ's intervention in this matter restores the balance that the Congress intended when they enacted Title II, and further ensures that ADA is fairly applied for the Americans with disability.
Let me ask you something. So, it was Chief Judge Hoffman, 12th Circuit opinion, said, if we allow intervention here, the government can intervene in any case involving any federal regulation. Is he wrong in that, or can you suggest a line that we can draw?
Justice Hoffman is not wrong in that statement. However, that does not apply to this case, as DOJ has Congress's explicit authority to intervene in this matter under Title II of the ADA. Furthermore, it is important to note that 70% of the residents of the state of Franklin is
does not have access to readily available community-based healthcare system. Therefore, this is the matter that requires immediate attention and relief. This shows that DOJ's intervention in this matter not only has legitimate enforcement authority, but also shows that without the DOJ, the entire state of Franklin will be vulnerable to the systematic statewide segregation. Congress vested the DOJ with enforcement authority by intent because the DOJ can address the wishes of the Americans with disability. Therefore, respondents respectfully request this court to affirm the decisions of the lower circuit. Thank you.
Your Honors, respondents' arguments fell for two reasons. First, the plain text of Title II simply does not include at-risk individuals. Second, the United States skipped the very first step that Congress required, pursuing voluntary compliance. Beginning with this first point, Section 12132 covers those actually currently institutionalized or denied services because of their disability, which mirrors the facts of Olmstead, which did not hold that you do not have to be currently institutionalized. And as Justice Kennedy wrote in his concurrence, that the inquiry is fact-specific. Here, the facts are clear. The respondents are not currently institutionalized and have not been in 3 years. Congress cannot be expected to write in every potential scenario, and courts should not expand the statute to cover what it did not say. It would turn Title II into an open-ended mandate, a free-for-all that swallows the limits Congress wrote, which goes to Mr. Chief Justice and Justice Brenner Johnson's questions about hypothetical standing. These risks are futuristic looking. The language is shall be, not may one day be. Second, the United States skipped the very first step that Congress required, which was pursuing voluntary compliance. Respondents impermissibly suggested that investigation is the same as pursuing voluntary compliance. But in the Florida case, the investigation with Florida lasted 6 months. Then it was 10 months after that for informal means for them to file their lawsuit. Here, it took 2 weeks, and the record is completely void of the United States attempting any negotiations with the state of Florida. Even if the respondents overcome the steep hurdle of rereading Title II's text to cover what it did not say, their lack of administrative mechanisms ends the inquiry altogether. As a reminder, the standard of review is de novo because this involves a purely legal question and no facts. For these reasons, petitioner respectfully requests this court reverse and remand on both issues. Thank you so much.
Thank you. We'll move this case and announce its decision in the future. Thank you.
Thank you.